Hello, my name is Alexandra Bondikov. I'm a business immigration attorney with Pollack, Isaac, and DeCicco. I would like to take this time to update you on the status of our operations. While in compliance with the governor's orders, our New York City office is no longer accessible to clients. We remain fully accessible to you through phone, email, Skype, Zoom. Rest assured that we are operating at capacity, although from home, but we will take care of your immigration cases and needs just like we have done in the past. It goes without saying that the coronavirus pandemic has wreaked havoc on all of our lives. Everyone feels the impact, financial or social. But for some of our clients who are here on non-immigrant work visas, such as H-1B, O, TNs, to name a few, this situation creates additional unique challenges. For them, reduced hours, layoffs, and furlough mean more than just loss of income. A layoff has an additional important consequence on their ability to maintain their legal status and remain in the United States. During the past week, many clients have contacted us with questions about their situations. The purpose of this video is to briefly address those questions and to try and alleviate at least some of the associated anxiety. So the very first questions that people ask us almost uniformly is, what happens if my employer lays me off, or I was laid off? What happens now? Am I still in status? The question is probably yes. Okay, it's a valid question. It's a valid concern because most employment-based non-immigrant visas are tied to a particular employer and a particular specific job. To remain in legal status, you must work for that employer and do the job as contained in the petition. So losing your job or being laid off from your job will affect your immigrant status. The good news here is that the United States Citizenship and Immigration Services has recognized that there are certain situations, or there may be certain situations when a worker loses his or her job through no fault of her own. They have written in a regulation that provides for a 60 days grace period in such cases. And this coronavirus outbreak will definitely fit the bill. So if you lost your job or you were laid off because of the coronavirus outbreak, you will now be considered out of status for at least 60 days. Now, we certainly hope that 2 months is enough time for this to blow over. But if not, if travel restrictions, closed borders, and canceled flights remain an issue, I believe that it's very likely that USCIS will come up with some measures to address the situation across the board. The second most common question people ask is, now that we've been laid off, we've lost our salaries, we have a family, how can I provide for my family? Can I apply for unemployment benefits like most of my colleagues in my situation? The answer is not that certain here. Maybe. And I'm saying maybe because unemployment insurance is governed by each state, and each state has different eligibility rules. Most of them require that the worker has worked a certain number of months or earned a certain amount of money through employment before applying for unemployment insurance. Another requirement that's almost uniform across the board is that the worker, while receiving unemployment benefits, must be able and must actively seek employment. And this is the requirement that most of the workers on non-immigrant visas will not meet. And the reason is that their status or their ability to work legally is tied to one particular employer. There is some good news here as well. As the pandemic progresses, many states are reconsidering and relaxing their eligibility rules. My advice is find your state's unemployment insurance website through the state workforce agency. Familiarize yourself with their requirements and check regularly as updates may become available. So that leaves me logically to the third question that people ask. Okay, you know, we're not out of status for 60 days. We live or we work in a state that allows us to apply for employment insurance. If we receive that unemployment benefit, will we be in violation of the public charge rule? And that has a very concrete answer: no. Unemployment benefits, despite being called benefits, are actually insurance. It's something that your employer is required by law to pay for to cover such situations. Your income level has no bearing on whether or not you qualify for unemployment. And unemployment benefits are not amongst the benefits specifically listed in the new public charge rule that may potentially make you ineligible for an immigrant visa or for extension or change of your current non-immigrant status. So to summarize, you're not out of status, at least for 60 days. You may be able to apply for unemployment insurance, but that's not certain. And if you do receive unemployment benefits, you will not be violating the public charge rule. Let me just take a moment to say that every situation is unique. I urge you to contact an immigration attorney to discuss your particular situation. We've touched briefly on layoffs and furloughs, but any material change to your non-immigrant employment can have immigration consequences, such as reduced hours or work from home if your home is in a different location than your office. We'll remain available to you. Contact us. We'd be happy to help and assist you through these difficult times. We will monitor the situation, and the goal is to provide updated videos as major news comes in. Until then, stay safe, stay healthy, and we'll get through this together.